Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today, we are joined by Harry Fine, who is a paralegal, a distinguished paralegal at one point there, an award recipient there, and he could tell you all about his career. It spans even longer than the licensing process for paralegals, and a lot of great information coming here. We'll talk about the landlord tenant board in particular for those who are interested there. And anything, if you have questions, certainly feel free to type it in the chat for those who are here. But Harry, first of all, thanks so much for joining us. And perhaps you can tell us.
It's my pleasure. I think you're doing a great thing here. So much content for your students and others. Congratulations on what you're doing.
Thanks, Harry. And so perhaps we can start there. I know we only have an hour, but I know you have such a long, distinguished career here. You can tell us a bit about how you got into becoming a paralegal.
It's a pretty strange story.
So it's like the history of the paralegal, right? Because before licensing, what it was like and what was it after, and kind of what you're doing right now.
Okay, let me tell you how it started. Actually, until I was 45, I was in the family business. Our family business was Bolorama. We had a chain of bowling centers across Southern Ontario, and we ended up selling it in about 2000. Bowling was changing. Real estate values were making bowling centers difficult to afford, make any money in. So we got out of the business, and good thing too, because so many of those bowling centers are gone today because of real estate values. They're now condos. And so I left at the age of 45 and thinking, what am I going to do for my next career? And I had a very strange way into this. I had a friend who was a politician in the governing party of the time. And he said, Harry, you're a smart guy. You've got some good legal knowledge. You did a lot of leasing and stuff. You'd be great as an adjudicator. And I said, what is that? I mean, I truly had no idea about agencies, boards, commissions, and tribunals in Ontario, that there were hundreds of them, and what a public appointee was and stuff like that. So I started reading, and he said, they're looking for people at the Landlord Tenant Board, which was not called the Landlord Tenant Board then. It was called the Ontario Rental Housing Tribunal. When governments change, they change the name to make it look like something's changing. So this was 2001, and it was just a few years after the Housing Tribunal was created. Just a little history. Before June the 18th, 1998, if you had a landlord-tenant dispute in Ontario, a residential landlord-tenant dispute, you'd be in the county court system. You'd go and see a judge, and the government decided to bring the landlord-tenant litigation, because there's so much of it, into a separate tribunal. So they created the Landlord-Tenant Board, or the Ontario Rental Housing Tribunal. They created the Residential Tenancies Act, which back then was called the Tenant Protection Act. And it was quite remarkable, because on January 17th, 1998, you would have been in court. On January 18th, you were at one of the regional offices in the administrative tribunal. It was like flicking a light switch. So I was not in the first group appointed. I was in the, second group. I guess it started in 1998, and I started in 2001. And it's an interesting process. The government puts your name forward. It has to be signed by the premier and cabinet. You're an appointee of the government, whether you're an adjudicator on the Human Rights Tribunal or the Social Benefits Tribunal or the Landlord Tenant Board, or you're a Justice of the Peace. You have to be appointed. And there's an element of political cronyism involved, and there's an element of merit involved. I like to think my appointment was all merit. And interesting, too, that when your name is put forward, the other parties, the parties not in power, have a chance to call you before the Standing Commission on Government Agencies, which is a commission, it's a standing committee of the Legislative Assembly of Ontario. And they can grill you and try to embarrass you or try to make you look good, whatever. And I was one of the lucky ones. They have a 10-day period to do that. And sure enough, I had to appear before the Standing Committee on Government Agencies, where the opposition tries to poke holes in you. But in any event, I was appointed in, I think it was November 2001. And I had a wonderful time as an adjudicator at the board. I learned so much. The government was helping me was training me in residential tenancy law. And I mean, at the time I was there, I heard thousands of cases. So you get really good at it without even knowing you're getting really good at it. And even today, 20 years later, I think when I look at a file or I look at a set of circumstances, I see the answer so quickly because you just don't lose that knack for sort of cutting through stuff. So I was an adjudicator for about 4 years, and then the government changed. And when I said before, it's a political process. It certainly is, because the Liberals who took power in 2003, they've been out of power since, 1995? And they decided, hey, let's put all our own people in as adjudicators. And we're appointees, we're not employees. And they have the right to just say goodbye. And they did. And they appointed their own Liberal appointees. And just like years later, the Conservatives now, 15 years later, the Conservatives took power and they're appointing their people. It's very satisfying being a public appointee, no matter where you're serving. Could be on a police services board, could be on a hospital board, could be on a tribunal of some sort that hears cases that's very court-like, which ours was. But at the end of the day, you're serving at the pleasure of the minister. So you got to be careful, because if you do it and you're 30 years old and you have a great time and you have a 10-year appointment, then you're 40 and you're out. And now you're thinking, what am I going to do with my life? So it's really not something for a 30-year-old or even a 40-year-old to look at, because it's something that ideally you'd like to have as the last 10 years of your career. So anyways, there I was. It was 2005. I think, oh my gosh, what am I going to do? And I thought, I learned so much. I certainly know residential tenancy law, but I worked very hard while I was there at the board to get my decisions correct. And to get them correct, you want to learn about different areas of law. And that includes, of course, at the Landlord-Tenant Board and for any court, the laws of evidence, which apply to any litigation, contract law, which applies to some extent to Landlord-Tenant Board hearings, because you're dealing at the Landlord-Tenant Board with a mixture of statute law and contract law. I learned about torts. I learned about real estate, real property law. I learned a whole bunch of stuff. And one of the most important areas that I think are important for a student today to learn to read about is administrative law. That is, because you're dealing in so many cases with government agencies. If you're dealing with defendants defending themselves against the government, or people making claims against the government, social benefits, for instance, or human rights, you need to understand your rights in relation to the government. And that's what administrative law is. People think admin law, some people think it's dull. I think it's the most interesting type of law, because you read the paper every day and you're reading about challenges to what the government tries to do. Government tries to build a pipeline and people have power. Government tries to, close a hospital and people have power. People try to, build a condo tower and, they end up before the licensing appeal tribunal because, they can't get approvals for things. So quite often in law, the government is a party to the action, and understanding administrative law helps you understand the reach of public power, the remedies against overreach of public power. So anyways, I learned a lot of this stuff, and I decided I'm going to become a paralegal. Now, this was 2005, and there was no such thing as a paralegal. I mean, there was no licensed paralegals. Anybody could call themselves a paralegal. And it was a problem because there were so many unethical people practicing in all sorts of areas, including family law, where they weren't qualified and they could call themselves a paralegal, and there was no education requirement, there was no insurance, there was no code of conduct, there was no governing body like the Law Society is to sanction you if you really messed up. And it was the Wild West before 2008. So after 25 years of attorneys general saying, we're going to license paralegals. We're going to license paralegals. Finally, and I guess it was Michael Bryant, I think, who was the Attorney General at the time, he said, we're going to do this. And they did. They amended the Law Society Act and a number of other statutes. And in 2007, the process started. And in 2008, we became licensed. And thank goodness, they had a grandfathering, should I call it now, grandparenting provision, so that people who have been working in the system for years, but didn't get trained by one of the accredited colleges like CDI, they would still be able to practice. And fortunately, I was in that boat where they looked and said, okay, if you had so many years before a court, then we're going to give you that privilege of taking the exam and becoming licensed. So I've been practicing now as a licensed paralegal since 2008 and really loving it. Most of my work, obviously, coming from the LTB was at the LTB. And I was still doing some small claims court work and human rights tribunal work. Those three tribunals, they're very similar in nature. They're, if you can do work at the LTB or small claims court or human rights tribunal, you can do work at any of the others. It's about knowing the substantive law, but you need to know procedures and you need to know rules of evidence, and you need to have advocacy skills. Those things don't change. And it's very helpful if you're doing some small claims court work, even if you're doing work for landlords or tenants, because often you end up enforcing judgments. So I get a judgment for $10,000 at the LTB. Now the client, the landlord, says, hey, how do I get my money? So clearly, I don't want them going to some other paralegal to enforce the judgment at small claims court. So that's sort of how you segue in there. During my, and JP, I'll talk forever, if you don't stop me. So if you have any questions, you stop me. During my career, I love to teach, and I still teach, but not in a structured way anymore. I taught at Humber, certainly for 3 years, part-time or partial load, they called it. I was teaching about 12 hours a week, and taught at George Brown as well. And I loved my teaching, but it was so hard to work on court scheduling of hearings and teaching. It was too stressful, too much, but I loved my teaching at Humber. I was teaching admin law, landlord-tenant law, small claims, practice management, ethics, probably missing a couple. And it's really so much fun. And I don't know the student mix at your college, but when I was at George Brown, I was teaching a group of mostly mature students, as opposed to people who just come out of high school in some cases. And I found them extremely motivated. And I really enjoyed that experience as well. And one of the fun things about teaching is at some point, my students would become my colleagues, and then they would become my friends. And I have so many relationships still, friends and colleagues who came from my teaching days. And it was a lot of fun.
So I'm going to jump in here.
I wanted
to talk, speaking of teaching, I know what you're doing right now in terms of training landlords, right? And I think that's an exceptional point, right? Is that there are a lot of people who in the landlord time board. You won't ever appear before the board if you're
just
doing all
another monitor here. I'm not ignoring you. I just want to.
If you are doing all your duties as a landlord, then your tenants can't be taking you to the board. So maybe you could tell us a little bit about those training videos and how that came about.
Sure. Let me go there. That's why I was looking at my other monitor. This is me. This is my website. I'm focusing now more on training, online consultations with Zoom, which is wonderful. I do take some files, but I try to keep them to a minimum, so my life has a little more time for my stuff as I get older. But I have a lot of courses for landlords to keep them out of trouble. And I say to people that it's easier to stay out of trouble to get out of trouble, then it's very true. So I have training materials for every part of landlord-tenant law, whether it's evictions, whether it's rent control, evictions for rent, evictions for conduct, evictions for personal use, going to the landlord-tenant board. Now, of course, the RTA has changed. There's post-tenancy claims where there never used to be the ability to sue a tenant at the board after they'd moved out. Talk about dispute resolution at the board. So they're all part of my repertoire of things I'm doing now. And in fact, I do a lot of live training for paralegals, which then becomes CPDs for paralegals or paralegal students, which are a little more in-depth and intensive than the ones I do for landlords. But the same thing, if you started practicing and you really liked landlord-tenant work, and you've got a taste of it in college, but you can't do everything and learn everything in that year. I find so many students or new grads or even current students come to my website, and by the way, I'm happy to discount for students, and they become experts because I really do cover it all. I sit and talk like I'm talking to you now, but with an in-depth, detailed PowerPoint as I go through things, with maybe a dozen documents filled in, completed templates and forms, so you have samples of things, really detailed professional samples of things that you can use before the board. So it's paralegals love my stuff. They say they're the best training materials. And in truth, a lot of those PowerPoints started with my PowerPoints I was using at Humber, and that I then, redeveloped. And of course, law is changing all the time. So it's not like, bang, I do one and then I keep the video. It changes all the time, and I've got to change it. So I'm really enjoying that, working with landlords. I actually, just strangely enough how it happened, I do a tremendous amount of work in the Chinese landlord community, partly because there are a huge number of Chinese landlords, and partly because they come from a system, those who can't come from the mainland and they've been here for a few years, where being a landlord is easy, and you're in a big power position against the tenant if you're in mainland China, but you come here and the system is so different. They get burned by the RTA, by the LTB, so they want to learn how to do it right. And so I have a huge number of Chinese landlord clients, and I have a huge number of Chinese landlord students who are, I'll show you the website just if any buddy eventually is watching this, who is from the mainland and is curious. It's called 58home.ca. And if you look through here, and I can't pretend to know where I am, but if I'm probably in here, if you look through here, you'll find training opportunities, and they do a lot of training. And there I am. And I used to do with them live. We'd go up to Markham is central for a lot of the Markham, Richmond Hill. We'd find a place and we'd meet live. Now we do it virtually. And I don't like virtual teaching. Nobody likes virtual teaching. I like virtual court work because I can be in court like in my underwear. I tell my wife now, I prepare for work in stages. First, I got to shave because I can't go to court with a beard. So I put my shirt on. And then maybe after my morning hearing, I can shower. So it's become like the 12 o'clock shower. It's a strange world now. But nowadays with the training I'm doing, it is done with Zoom, and it's trickier, but it's necessary. And the beauty of Zoom training, of course, is I have people in the current course that I just completed, which was 8 weeks. I have people from KW, Kitchener-Waterloo, and Guelph, and Burlington, and Barrie. So those people probably wouldn't have gone to the course if it hadn't been for the fact that we're doing it through Zoom. But I get tremendous satisfaction from it, and keeping my hand in with actually working at the board, taking a few cases. For me, it's a perfect work-life balance. Now, don't get me wrong, you haven't always been able to do this. I worked like hell and worked very hard as a sole proprietor for many years, but now I'm at a position in life where I can do that. There have been tremendous changes at the Landlord-Tenant Board, both in the RTA over the last 2 years, brought about by Bill 184. I have a video on Bill 184 at my website. Maybe what I'll do, if that works for you, JP, I will send you, no charge, I will send you my Bill 184 PowerPoint and video link, and you can do what you'd like with your students and share it, because it gives you some good background of what changed in 2000 and 2001. When Bill 184 came in, well, let me go back to Bill 184 in a second. The Landlord-Tenant Board website is telling you here that some interesting things are happening, and they certainly are, because everything changed with COVID. And courts were the most backward institutions in terms of technology. And no, they said they could never change. It just wasn't doable. But of course, with COVID, everything became doable. And
yeah, maybe you could tell us about some of those changes.
I absolutely will. And I'm just showing you again, from my main page, you can get to my blog. And I just wrote a blog last week, a few days before the changes came into effect. Now, these aren't legislative changes. These were changes in how the Landlord-Tenant Board, as a pilot project for Tribunals Ontario, is going to be taking a digital-first approach. So everything we used to do as practitioners, in terms of how we filed, how we exchanged documents, how we mediated, how we accessed the board in every way, has changed. Fax is dead. Yay. Long, never thought that would happen. But I've got a good blog post here on the changes that actually took effect on December the 8th, just very recently. But let me go back, as JP asked, to Bill 184. Every government puts their stamp on legislation, and the Tenant Protection Act in 1998, it's had so many minor amendments, and then a big amendment in 2007 becoming the RTA when the government changed. Government changed in 2003. It took them 4 years or 3.5 years to proclaim the RTA, because new governments take power and there's lots to do. And even though Dalton McGuinty during the campaign said within 1 year, he promised, we're going to scrap the TPA and bring in real rent control, which, by the way, has a meaning. And we're going to do it within 1 year. Now, of course, he lied in every which way. It was 3.5 years. How do you know when politicians are lying? Their lips are moving. That's another story. So, and they didn't bring in true rent control, because what true rent control means to people in the know is that a unit, the unit's rent is controlled. Even if Joe Smith moves out and Mary Jones moves in, the unit is subject to rent control. What we have in Ontario now is a system called vacancy decontrol. It means that the rent is controlled, but once a new tenant moves in, rent can go up, they negotiate, whatever. So McGuinty promised within a year he'd bring in vacancy decontrol, rent control. And of course, it was 3.5 years and there was no true rent control. But in any event, 2007 was a big change as the RTA came into force. And then the government changed again in 2018. Doug Ford was elected. And a year later, he made a couple of minor changes. But then 2 years after he was elected, the government, the Conservatives, introduced Bill 184. And Bill 184 brought some huge changes to the RTA. Still called the RTA, but huge changes. The biggest change from the landlord's perspective is that Bill 184 finally made the Landlord-Tenant Board a one-stop shop for all residential landlord-tenant litigation. Prior to that, there was a bifurcation. That means a split. Sometimes you went to small claims court. Sometimes you went to the Landlord-Tenant Board. If you didn't file the application while the tenant was still living there, but then the tenant moved out, without paying rent and you had 5,000 owing, but you never filed at the board, and then you found 10,000 in damage, you'd have to go to small claims court. There were other types of claims like utilities and some other things that had to go to small claims court always, whether the tenant was in possession or not. But come Bill 184, which was brought into force on July 20th, 2020, or July 21st, 2020, the LTB became the one-stop shop. Now, in truth, when the bill was proclaimed, it was only proclaimed in pieces, because when a new bill is introduced to amend a law, there are many sections of that bill, and sometimes the government has to delay bringing them into force, even though it's passed and even though it's been signed by the lieutenant governor. They then bring it into force in pieces. Why? Well, they might have to do some forms up. They might have to make some website changes. They might have to train people that handle the call center. They might have to train adjudicators. And there are other reasons. I mean, there are pieces of legislation. One is the Condominiums Act, where just this year, January 1st, some pieces are coming into force, changes in the Condominium Act that I think were passed in 2015. No kidding. So anyways, a lot of things came into force from Bill 184 on September 1st, 2021. And that included the one-stop shop stuff, which is great. For paralegals, it's great. You have one place to go rather than have to worry about small claims court going the two places to litigate for residential landlord-tenant matters. Another big change that was made, both in 2017 by Kathleen Wynne before she lost in a landslide to Doug Ford in 2018, and then again in Bill 184 in 2020, was some changes in the way no-fault evictions take place. And no-fault evictions are evictions that take place without the tenant being at fault. And those are things like the landlord wants to move in, the purchaser wants to move in, the purchaser wants to do extensive renovation and needs the tenant to move out, the house is being demolished, the property is being converted to something non-residential, no fault of the tenant. And we call those the no-fault evictions. They use the N12 and N13 notices. And there's terrible abuse by landlords. In fact, follow me on, if you like this stuff, follow me on Twitter, because that'll tell you whenever I've done a new blog, or whenever I've got some sort of newspaper article or whatever. On Twitter, I am Harry_Fine. And for instance, just the other day, well, there's JP's piece. I did an article that for Now Toronto Magazine about how badly these no-fault eviction things are abused by landlords. And then just a couple of days, well, that was my graduation ceremony for my Chinese landlord group. But a couple of days before that, I was on CBC Radio in London. They were dealing with the same topic, and you can get the audio of the London Morning Show as well as the link to my blog there. But the reason it's getting so much airtime is because, JP, I guess I'm not allowed to swear on your podcast.
Oh, you can.
Okay, because so many of those N12s and N13s are bullshit. They're just phony. They're the landlord, because we have this system of vacancy decontrol, which means that if they can get the tenant out, they can raise the rent finally. There are so many people using N12s and N13s in bad faith. So in 2017, Kathleen Wynne, and then in 2020, Doug Ford made changes trying to make it harder to do BS N12s and N13s. And then if you do evict a tenant and ultimately you don't move in, or your son doesn't move in, or the purchaser doesn't move in, the law has changed. So there's huge penalties against landlords or purchasers for having given that bad faith notice. And when I say huge, you can now, if you're a tenant and you found out that your landlord re-rented the place instead of his son moving in like he said on the N12, and you found out that he put it up for sale or put it up to re-rent, you can sue the landlord of the LTB up to 1 year from the time you moved out. And you can, if you're successful, get up to $35,000 in compensation. The landlord can be fined by the board up to $35,000. And more than that, and since this is a legal group, I'll do a little legal stuff here. And, you know, I'm really big on, I guess because I was an adjudicator, to me, understanding statute is important. Some people say, sometimes people call me, what are the most important things I can do to be a good paralegal? Well, I'll tell you how. Go to hearings, lots of them. And now, with hearings online, there is no excuse. I still sit when I'm doing casework or just sitting playing at home and I'm not working that day. I sometimes have LTB hearings on in the background so I can just see what's in people's minds, how different adjudicators are reacting to things. So there's no excuse not to spend lots of time in court watching anymore. No excuse at all. Second thing, read lots of case law. So for instance, let's say you are doing landlord-tenant work. So I go every week into Canley, into Divisional Court, type in Residential Tenancies Act, because that's going to be in every decision, filter by date, and I see anything new from Div Court or anything new even from Superior Court. I can go back, or Court of Appeal. And I want to know every case that's new that's been decided because there's lots of LTB appeals. So read case law, lots of it. By reading case law, you'll understand how judges think. You'll understand administrative law. You'll understand what a finding of fact is. You'll understand how the application of law to the facts is important. And if, as a practitioner, if your facts don't line up with the law at the end of the day, you lose. And so, and I don't know how many of you will understand me when I say this, people that are really good in terms of advocacy, they work backwards. They start with, what's the case law? What's the definitive case on drunk driving or on assault or on the elements of a contract, the new element of good faith from the Supreme Court. So they start with that, and then they try to work back to their evidence, and they're working with their clients and they're preparing their client for a hearing to make sure at the end of the day, all that evidence lines up with the case law so they can do killer closing submissions. So anyways, watch lots of court cases, read lots of case law. Those are two really important things that you can do. But I was talking about the new sanctions for landlords. Well, first of all, this is the RTA. And let me even step back a step. I like doing things in order. To be a good paralegal, you need to understand how government works. You need to understand how laws are made. You need to understand the process of making laws. What is first reading and second reading and public consultation and debate after second reading, and what's third reading, and how laws get amended. And you need to know how to look up laws and how to read laws. I've often thought that people that are good at coding software are very good as paralegals, because when you're reading statute, you're often reading lots of subroutines and branches and if-then conditions. And if you don't get those, if you can't train your mind to think logically, then it's very difficult. Because I always tell my colleagues, and I get mad at them, they say, Harry, why did the adjudicator do this? The form says this. And I say, don't look at the damn forms. The forms are not the law. The forms are the best representation that the government could make of what the law looks like for simple people that aren't paralegals. Always, always go back to the statute and understand that every word in the statute has significance and meaning. So here I'm showing you, for instance, Section 57, which are the new remedies for a tenant if the board finds that the landlord gave bad faith notice. And in 57 sub 3, you see they can give an order that the landlord pay a sum to the former tenant of any of the increased rent that they incurred for a year. But here's a new one from Bill 184, an order the landlord pay an entire 12 months rent back. Entire 12 months rent back. Out-of-pocket expenses for moving and storage, a further abatement of rent, a fine to the board of up to $35,000. So I was going to tell you that, and I will tell you that there's something else bad that can happen to a landlord. And I'm doing this now as a teaching moment. If you look at most provincial statutes, at the back end of the statute, there is a section called offenses. Because if the Highway Traffic Act didn't have offenses, then everybody would speed. And the RTA is no different. And people get confused by this, but sections 233 to 238 talk about offenses under the RTA. And sometimes new paralegals get confused and they say, what are these? Do these have to do with the landlord-tenant board? No, not at all. They're provincial offenses created by the RTA for things that are so serious that the government has decided that in addition to the bad things that can happen to you, landlord or tenant, at the LTB, you can be charged with a provincial offense and prosecuted by the Ministry of Housing in Provincial Offences Court. So a person is guilty of an offense if da-da-da-da-da-da-da. Well, one of the things that they can be guilty of an offense is for obtaining a property by giving bad faith notice or by providing false and misleading evidence to the board. So what can the penalty be? A person other than a corporation who is found to be guilty of an offense under this act can be fined up to $50,000. So in addition to the bad things that can happen to a landlord at the LTB if they're found to have given bad faith notice, they can get whacked in Provincial Offences Court. This was raised from 25 to 50,000. But look at this. A corporation that is guilty of an offense under this act can be fined up to $250,000. So if the homeowner, the landlord, happened to put his property in the name of a corporation and then was found to have given bad faith notice, and again, learn how to read statute, you'll see that this section was most recently enacted in 2020 by certain schedules of certain bills. So get to know statute, read cases. Those things will stand you in good stead. From a non-legal perspective, how do you do well? Care about your clients. I mean, two ways. Understand technology and have a good website, and use social media properly. And the second thing is care about your clients. You have to put your interest above their interests, above your interests. You have to really care about the outcome. I have never had problems attracting clients because I manage their expectations. I tell them what I think the outcomes could be. I work my hardest to get them the best outcome, and they love me. And they know that I've tried my best, even if we lose. Because often when a tenant's being evicted, for instance, because a landlord really wants to move in, and I do work for tenants as well, I tell the tenant, you're probably going to get evicted because I think this is a good faith application. I think these people are really moving in. But maybe I can get you $10,000 through negotiating. Maybe I can get you an extra year. So when they're evicted with an extra year, like they're crying as they thank me for the great job I did, because I've managed expectations. It's important in our profession to manage expectations, not just say, oh, I can do that. Oh, don't worry about that. Oh, this is easy, because it's not, and you can't guarantee success. You need to really understand that you're a professional with a responsibility to do the very best you can every day for your client. Keep out of trouble with the Law Society. But more than that, just do the right thing for your clients, and you'll never have an issue. Any other questions, JP, or any other?
Yeah, lots of great advice.
Let me talk about. I'm happy to talk about what's happened to the LTV since.
Yes, let's talk about the and maybe you can touch on. I think for students, especially digital, and you were saying, the struggles of teaching digitally or electronically. What have you found in doing things at the board in terms of hearings electronically? And you said it's great. Obviously you don't have to take a shower till noon and all of that. Good. But what else is there in terms of being an effective advocate virtually versus in person?
It's interesting, and I really encourage you, not because I'm looking for Twitter followers, but I am. Follow me on Twitter. Today, I posted a retweet from a tenant advocacy group called ACTO, and it was an article on CBC where ACTO said that they're concerned about the landlord-tenant board's online transition because people who are marginalized, people who are poor, people who have mental health issues may not be able to access this new technology either because of cost or knowledge. So there's a whole article on it today talking about the problem. So do I like it? Well, it's coming. I like the fact I don't have to drive to the hearing. I like the fact I don't have to put on my winter coat. I like the fact that I don't have to leave home. Do I think it's good for justice? I can't say I do, because you're not there in court where the judge can look at the parties and the parties can look at the judge. It concerns me very much that just like taking exams virtually, people can be coaching witnesses online. It concerns me very much that some people say I don't have a camera, so the board can't see them at all. And who knows if they're being coached? It concerns me sometimes that adjudicators who are working from home where they have low bandwidth sometimes tell the parties to turn off their cameras, or even they turn off their cameras. And I don't think it's right on a contested matter where the credibility of the parties is an issue for the judge and the witness not to see each other. I saw a terrible thing a couple of months ago while I was waiting for my hearing to come, where the adjudicator had her camera off. And there were paralegals on both sides of this matter. And there was testimony being given by the tenant, and the landlord's paralegal objected. So when somebody objects, everybody stops, and the adjudicator rules on the objection. So the adjudicator overruled the objection. And I thought that was strange, because I thought that was a pretty legitimate objection. And then about 3 minutes later, the paralegal objected again. And the adjudicator overruled the objection. And then the paralegal said, Madam Chair, but they really argued. And the adjudicator turned her camera on and said, tell me again, why are you objecting? Well, I think she was sleeping on the first two. I think she was watering her plants or feeding her dog. I love my dog, but if I'm conducting a hearing, I shouldn't be, feeding my dog. And I think there's too much of that's happening. And it really concerns me. There's also the whole problem of, and I hear stories of tenants, standing in the pouring rain who don't have a phone, let alone internet, and they're standing at a phone booth conducting a hearing from a phone booth in the pouring rain. So these are real problems. So what's the LTB done since COVID? Well, when COVID came, there was already a big backlog by March of 2020 at the LTB, because Doug Ford had not reappointed people. God knows why. Kathleen Wynne didn't reappoint people in her last year before she was trounced. So, and then Doug Ford for 2 years. So it's like 3 years adjudicators' appointments ran out or they quit. So there was probably like a 4-month backlog for a hearing in March of 2020. And then the LTB closed for 5 months. Imagine that. There was no hearings for 5 months, no evictions for 5 months. And during that time, the LTB was working on what are we going to do, like every other court. And to their credit, they came up with a basic framework that around August the 4th, the sheriff started enforcing, they started having hearings, but they now had orders that hadn't been sent out, where the landlords had served N4s in October of 2019. So we're talking about almost a year, and if rent was like, $3,000 a month, let's say, an expensive rent, these people owed $30,000. I had one client who, by the time the LTB opened up again in August, the rent was $6,400 a month. And she'd actually had a hearing on March the 12th. The tenant didn't show. She got her uncontested order. The tenant at that point owed about $35,000. March the 12th. March the 16th, the LTB closed. The order never went out, had never been written. By the time she got the order, it was the end of August. The tenant owed $65,000. Then he filed a review. He told me he was going to file a review. When I called him and tried to settle, he said, I'm going to file a review and tell them that I didn't come to the hearing on March 12th because I was afraid to go because of COVID. Ha, ha, ha. He actually admitted to me he was going to scam the court and the landlord by saying that's why he didn't show up. That was his plan. Anyways, by the time that the tenant was finally gone, it was like $100,000. But the maximum LTB monetary jurisdiction is $35,000. The landlord will probably never see one penny of that $100,000. So anyways, the backlog for a new hearing, if you filed in August of 2020, it's like 8 months, 10 months. So it's been a train wreck. The LTB has been a train wreck. And when I say that, I'm sort of being insulting to wrecked trains because it's maybe worse than that. And for us practitioners, it's been stressful. We file things, they lose it because now they've got a new online system. You can finally email file. You can not only email, but they have e-filing for certain types of applications, like with Wizards. Fax is gone. Zoom, they started off with Microsoft Teams, then went to Zoom. Zoom was a mess at first. It was only one room really, but now they've got breakout rooms for mediation, breakout rooms for tenant duty counsel, breakout rooms for different hearing rooms. They've hired a lot of new or appointed a lot of new adjudicators. They've put a lot of mediators into the breakout rooms. So today, the system is pretty good, except for those people who are calling in from a phone booth in the pouring rain. One of the big advantages to the new digital-only hearing process, because there are no in-person hearings. All these board offices with, I don't know if you in your career as a student, because I mean, when you started your course, all the hearing rooms were closed. I'm not sure if you've ever been to a real hearing in your program. But all these hearing rooms, these buildings, these office buildings where they had hearing rooms, they're all closed. The front counter desks, they're all closed. Everything is done by email, which before was like, oh no, you can't do email. It was like they were in the 18th century, these courts and tribunals. Same with small claims court, but they're now doing everything online. So, I mean, Zoom meetings, except for the problem of coaching of witnesses, that concerns me a bit. But one of the nice things it's done at the LTB, their rule about disclosure of documents used to be there is no rule. In other words, in the days that we had in-person hearings, we used to go to the board, and unless there were two professionals on the file, the tenant would give you their documents at the hearing, and you'd give the tenant your documents at the hearing, and then you'd stand up and say, Madam Chair, I just got 100 documents today from the tenant. I'm not ready to go today. I've got to bring my superintendent in. I got to bring the plumber in. I'm going to need some witnesses. I didn't know these were going to be issues. And that was terrible. It was trial by ambush, which meant adjournments, which meant delays, which meant more backlog. But now, finally, and it's a good read for those of you who are interested. If you go to the LTB website, and it's a good website, for all I may criticize the LTB, it's a good website with lots of stuff, including this new Tribunals Ontario portal, which is the way to file nowadays since December the 8th. They have a really good number of interpretation guidelines, which if you understand admin law, you know what those are, and rules of practice, which is, again, if you understand admin law, you know what those are. And they have rules 3 and 5 have changed extensively about service of documents on other parties. So now there are very strict rules that say 7 days prior to the hearing, the applicant must have provided all their documents to the other side, any documents they intend to rely on. And then the respondent 2 days later, within 5 days, at least 5 days before the hearing, has to provide their documents to the other side and the board. And the board has a special email address dedicated only for you to send evidence for a hearing, where you put the file number and the word evidence in the subject line. And hopefully on the day of the hearing, the adjudicator has all your documents in front of, and it's working now. It is working. So it's a mixed bag. There's good, there's bad. But it is the way of the future. It's just going to be. I remember last year in March when they were talking about trying to do virtual hearings. And I predicted last March, I said, we're never going to have in-person hearings again. And people said I was crazy, but they're not calling me crazy now, because I don't think at the administrative tribunal level, small claims court, I don't think there's going to be in-person hearings again.
I mean, certainly maybe it's trying to find some sort of way to accommodate those who don't have internet computer issues. Like you said, I mean, that's probably the next little thing to take a look at. If there's like a hub or something,
remote,
yeah, like a little work, like one of those remote office spaces where you can come in, and rather than having in-person hearings, you have these little small remote rooms
and
across
the LTB has sort of done that in various regions, but you have to file a request for it and get approved, and it's a process. And in landlord-tenant law, it's unfortunate and it's sad, but particularly in the big cities like Toronto, where there's such a homelessness and mental health problem, you get a lot of tenants who are respondents of the board that don't have the ability to properly respond to an application against them, or even make requests like, can I have a place for a hearing, or understand how to submit evidence. And that's the concern ACTO had in that article from CBC today, that people are going to fall through the cracks, and it will absolutely happen. I know that I've been watching the clock, and I know my hour, I think, is almost up.
Yes, Harry. So it was a very informative hour, entertaining hour, lots of information. And again, I'll follow up with you with some of those resources.
And I'm going to send you that Bill 184 stuff. And if anybody wants to, connect with me, or just send me an email to say hi, I'm happy to answer questions. I do enjoy mentoring, as long as people are pulling their end, and I'm happy to be a part of that solution.
Perfect. So here, maybe if you can conclude with some final words of wisdom for all the students and practitioners that are listening about practicing, in particular the landlord-tenant board in the future, and looking forward for the students who are going to make that transition to become practitioners. Thanks again for taking the time and sharing all your valuable insight with us, and thanks for everyone for tuning in.
It's my pleasure. Just get to know, get involved in the industry now. Like, join the OPA now. Start joining, Facebook groups. There are a lot of good ones. I'm the admin of the OLTB Facebook group and the Small Claims Court Facebook group. Join those now. See what sort of things we talk about. Get your name known. People that show up and have never been on the group, and they join one day and say, "Hey, I need some hours, my 120 hours or whatever your school does." It doesn't work. You need to contribute. You need to give. You got to sacrifice other things in your life. have to be put on hold while you're doing this. And I know it's tough. Many people, are raising families. Many people, are working full time and doing this. Really, really tough. And I respect you for doing that. But it's a great career, and you got to differentiate yourself, work hard, and you'll do okay.
Perfect. And what were the Facebook groups? There, I see a question about.
Well, if you in Facebook, if you just search for OLTB, you'll find the Landlord Tenant Board one. And if you search for Ontario Small Claims, you'll find that one. And I'll just say you're from, there's 3 questions you got to answer. If I see them from your school, I'll just admit them from your college.
Perfect. So thanks so much again, Harry. Excellent talk here. And
I just realized I said some other school earlier instead of trios.
It's fine.
My
we're
bad.
all about providing, any student anywhere, resources. I think all I want to see is certainly the profession continue to grow and people having resources and access to mentors like yourself there. Sometimes, it's just easier to just, hey, I listened to you talk. Maybe, I have some questions, or I'm a landlord. I mean, there's probably some landlords in here. They're like, hey, I never knew that I couldn't just say the purchaser's planning on buying it, and then turns out they're not moving in, and now they can raise the rent, because then they may be on the hook, right? The new purchasers,
sure are, yeah.
Because they ended up trying to rent it to somebody new. They want it unoccupied, right? So lots of great information there. Again, there's lots of resources there, lots of links to connect with Harry. And thanks again for everyone for tuning in, and hopefully see you again tomorrow.
Take care. Bye-bye.